Hello, Dr. Ryder. This is my case is Henches versus Taylor. This is the case where Jim Henches he sues Benjamin Taylor over a disputed debt. During the case, there is a key mistake that Mr. Henches did that ended any chance for a lawsuit. On the other hand, Mr. Taylor Mr. Benjamin Taylor and his legal team, they handled the situation ideally. They covered their tracks with precise wording to make their intentions perfectly clear. The plaintiff is Jim Henches. He's a licensed massage therapist. And the defendant is Benjamin Taylor. Jim Henches, he billed Benjamin Taylor, who was a car accident victim, for more than $7,000. Taylor's insurance paid $2,625 for 24 massage treatments. Henches then he continued billing, not for the balance due, for additional time spent talking to Mr. Taylor's lawyers and other healthcare providers to testify in Mr. Taylor's personal injury lawsuit and attempting to collect additional debts. Henches then sends a bill for $11,945.86. Taylor's lawyer, James Harris, sends Mr. Henches a letter. According to their calculations, Henches is still owed $5,243.45. And he wrote a check, and with that check for 5,000 and that check Mr. Taylor's lawyer and Mr. Taylor, they wrote a check out for $5,243.45, which is a check for amount as payment in full to settle. That is the letter that they wrote to him. Then they sent the check, and on the check, on the notation line, they wrote "final payment written" on there. Now, Mr. Henches, he was right to file a suit seeking for the full balance of the dispute. But then he was wrong when he got the letter. On top of it, he wrote, on top of the check, he wrote, where it said final payment, he wrote attorney fee above final payment. The trial court gave a summary judgment to Taylor, being that Mr. Henches made a fatal error by depositing the check. So the trial court gave a summary judgment to Taylor, ruling that the deposit of the check, it constituted an accord and satisfaction. And the accord and satisfaction is three circumstances in order to meet that. And the parties have a legitimately disputed debt. They agree that partial payment will settle the dispute, and defendants accept the partial payment. So that's where he messed up. The defendant accepted the partial payment. All right, Henches entered a unilateral contract by doing that, and by cashing the paid in full check. Mr. Henches meets the requirement in order to enter a new contract, which is the offer proposed by the lawyer. And the requirements to a contract is lawyer offers. There's an acceptance, such as in responding in a certain way, which was cashing the check. The satisfaction. Taylor's lawyers attempted to a legal term of accord and satisfaction. The third one is consideration. Is the money being paid? The legality of it. It was legal. Capacity. He wasn't in a bad state, and consent was cashing the check again. So he met 6 of the requirements to enter a contract. The writing attorney fee over the word final shows that Henches knew that Taylor was trying to settle with the check being the final payment. Depositing the check reinsured that the check would be the final payment. Henches should not have cashed the check while in dispute. Seeing that Taylor sent the check with final payment written on it, it should have been a red flag and the check should have not have been cashed. Henches should have sued for $11,945.86, which he believed he was owed. This case, it explains the importance of explaining what the check, what the notation line is on a check. Depending on what Taylor wrote or did not write, is the foundation of the defendant's defense. Had Taylor not written anything in the notation line, Mr. Henches would have still had a certain lawsuit for the remaining dispute. Henches writing his own attorney fee on the notation line would not have necessarily been an attorney fee just by him writing it on there. The dispute still would have been, still could have been litigated and decided by a judge. I also believe that Mr. Henches, by writing on the check, is a borderline fraud he was committing, but he did acknowledge that it was his writing, so it wasn't exactly fraud. If it was left blank, then, like I said, it would Mr. Henches would have still had a case, because then he would have been able to. Dispute. He could have accepted. He still could have cashed the check, and it would have been the remaining balance that he would have been able to sue and let the judge figure it out from there. So this case has a few important elements to it of knowing the importance of writing what something is for on a check on the notation line. Is there for a reason. A lot of times, a lot of people don't write anything on the line, but as you can see, that right there was his defense, being that he wrote payment in full. It shows exactly what it was intended for, and by him sending the letter, and then Mr. Henches cashing the check, it showed that he accepted the new contract that they made to end the dispute. Mr. Henches, he had a legitimate claim, if he felt that he was still owed money, but he went about it the wrong way, and maybe he needed that money at the time or whatever, but he cashed the check. It said final payment, so that's going to be the final payment, according to the judge. So yeah, it's a pretty interesting case. So if you have any questions, then I guess you could email me back. But that's my case. Mr. Henches versus Mr. Taylor. Thank you.